bring this up. Recording on the cloud. David, can you hear me? I'm just making sure we talk. David, can you hear us? When we speak? Tell us, yeah, let's go there.
Good morning, everyone. Welcome. Thank you. We are ready to start this morning. We're here today at the Marriott Hotel in downtown Toronto. Just some housekeeping just before we begin for those who gathered here today. The exit, fire exit towards the left. Washrooms are towards the right. Please don't use the elevator in the event of a fire alarm. Please use the stairs that are out towards the left. Good morning, everyone. Welcome. My name is Ketpana Nagendra. I am the Secretary and Official Spokesperson for the Tamil Rights Group, TRG. Before we begin, TRG respectfully acknowledges that we are meeting today on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe of the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse nations, First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. We thank you for allowing us to continue our work in your territory. Thank you to those who are here in person with us and everyone who is joining virtually from around the world this morning, from various parts of North America, Europe, Australia, India, Sri Lanka, as we announce a significant campaign for justice and for Eelam Tamils. This morning at 9 a.m. Central European Standard Time, Tamil Rights Group, in collaboration with International Tamil Refugee Assistance Network, ITRAN, submitted a communication under Article 15 of the Rome Statute to the Prosecutor of the International Criminal Courts in The Hague, Netherlands. The aim of this communication is to refer atrocity crimes committed against Eelam Tamils to the International Criminal Courts and to request the prosecutor to initiate an investigation on their report, also known as proprio motu, into crimes against humanity perpetrated by Sri Lankan officials. The goal is to make the perpetrators of such outrageous crimes accountable for their actions and to be brought to justice to end the impunity that is prevalent in Sri Lanka. We are hoping that the pertinent facts and the arguments presented in the communication will persuade the prosecutor to open a preliminary examination that will ultimately lead to the identification and prosecution of the perpetrators to ensure that such unimaginable atrocities that deeply shock the conscience of humanity will not go unpunished, as affirmed under the statutory framework of the ICC. TRG, Tamil Rights Group, is an international not-for-profit organization that was established earlier this year and headquartered in Markham, Canada. TRG seeks to strengthen advocacy efforts for transitional justice and universal jurisdiction for Eelam Tamils through leveraging international law, expanding global diplomacy, and defending their civil liberties within Sri Lanka. TRG brings together a multinational generational team with deep networks within civil society in the traditional homelands and across the diaspora, and activists directly connected to the struggle for Eelam Tamil rights since the early 1970s. TRG is firmly committed towards the relentless pursuit of justice and accountability for Eelam Tamils using all avenues available under international law and human rights principles. International Tamil Refugee Assistance Network, ITRAN, is an international non-governmental organization that is actively involved in helping refugees who have been displaced by violence, conflict, and persecution to survive, recover, and rebuild their lives. ITRAN works to address the global Tamil refugee crisis by protecting Tamil refugees and displaced persons around the world and promoting durable solutions. ITRAN sees the large impact the deportations and persecutions have had on the Tamil refugee and displaced persons population. And ITRAN believes that ending impunity for these crimes, including the ICC, is important for promoting durable solutions. We are gathered here in the city of Toronto, home to a significant portion of more than 300,000 Eelam Tamils who have fled persecution, torture, rape, civil and economic unrest, and genocide from the island of Sri Lanka to seek refuge in Canada. The story of TRG is really the story of many Tamil Canadians, including myself. I came to Canada when I was 5 years old after being caught in the violence that erupted in Colombo, Sri Lanka during the 1983 anti-Tamil program, also known as Black July. Our house was targeted and attacked and destroyed by angry government-sponsored Sinhalese mobs as my sister and I and mother fled for the mere fact that we were Tamil, a minority by population in that country. These riots in 1983 resulted in a brutal war that lasted 26 years. However, the violence and the systematic structural and cultural genocide against Eelam Tamils originated in the early 1940s and continues today under the Rajapaksa regime. The end of the war in 2009 was not a simple cessation of hostilities in Sri Lanka. Hundreds of thousands of innocent lives were lost, and 12 years later, we have yet to see any resemblance of accountability or justice for these crimes against humanity. The Sri Lankan government has shown no interest in domestically bringing to justice those responsible for crimes against humanity. In fact, they have done nothing but protect such individuals. In 2009, we as a community marched along these Toronto streets, blocking the Gardiner Expressway at some point in desperation, chanting, pleading, begging for the international community to notice, to take action against what we knew was unfolding in Sri Lanka at the time, all in the pursuit of justice for the Tamil people of Eelam. We were demanding recognition for the atrocities being committed. We wanted intervention to prevent the loss of and protect the lives of our family members. And in the end, we felt defeated and hopeless. However, as a community, we did not let this defeat define us. As a community, we went back into our homes to reflect and to chart a new path forward. As a community, we decided that more was needed to be done and a new approach was needed. The next generation of the Tamil community has stepped up to this challenge on this new path, and we have now embarked on many initiatives legally in the pursuit of justice for the ongoing genocide in Eelam. In this pursuit of justice, I'm joined here today by TRG's legal advisors and representatives of ITRAN, David Mattis, who's joining us here from Winnipeg, Manitoba, and Sarah Teach, who's here with me here in Toronto. David Mattis is an immigration, refugee, and international human rights lawyer. He is a graduate of the universities of Manitoba, Princeton, and Oxford. He has taught at the universities of Manitoba and McGill. He is the author of 11 books on a variety of human rights subjects, and in 2007, he was awarded the Order of Canada. David will be addressing you shortly with his remarks regarding the current ICC and how we can access the courts for justice and accountability. Sarah Teach is an international human rights lawyer based in Toronto, Canada. She is a senior fellow at the Macdonald Laurier Institute and a director of the International Tamil Refugee Assistance Network. Sarah holds a Juris Doctor's degree from the University of Toronto, an MA in Counterterrorism and Homeland Security Studies, and undergraduate degrees in Psychology and Sociology from McGill University. She also studied law at the National University of Singapore and previously worked on classified projects at the International Criminal Court in The Hague. Sarah will provide her remarks shortly after, where she will get into more specific details regarding our legal submission this morning. Thank you everyone for listening to me. I apologize, we might have had some AV issues and may have lost my video feed at some portion. I hope that the audio was clear and concise. And now I'd like to turn it over to David Mattis. Thank you, David, for joining us here from Winnipeg, Manitoba. And I will hand the mic over to you for your remarks. Thank you.
Submission is considered by the court, a submission which will be summarized by my colleague Sarah Teach. A prior question arises. We have to consider how practically we can get the crimes of Sri Lanka before the court. There are generally basically 4 different ways to draw matters to the attention of the court. One is for a non-governmental organization to approach the office of the prosecutor directly to launch a preliminary examination of the crimes, and in this case, the crimes committed in Sri Lanka or by Sri Lanka that are within the jurisdiction of the court. A second way is to ask states parties to the court treaty to refer the situation, in this case, the situation in Sri Lanka, to the court. We note there are 40 states which are both parties to the court treaty and co-sponsors of the Sri Lanka resolution at the United Nations Human Rights Council calling for accountability. A third way is to ask the states, which are both members of the UN Security Council and co-sponsors of the Sri Lanka resolution in the UN Human Rights Council, and there are 6 of them, to ask the Security Council to refer the situation in Sri Lanka at the end of the Civil War to the International Criminal Court. And a fourth way is to ask the Office of the UN High Commissioner for Human Rights to recommend to the UN Human Rights Council to recommend in turn to the Security Council to refer the situation in Sri Lanka at the end of the Civil War to the International Criminal Court. Today, the first approach has commenced. The Tamil Rights Group and the International Tamil Refugee Assistance Network have jointly asked the Office of the Prosecutor directly to launch a preliminary examination of the crimes committed against Eelam Tamils in the context of the Sri Lankan armed conflict. The preliminary examination has to determine whether there is a reasonable basis to proceed with an investigation into the situation. In making that determination, the prosecutor has to consider jurisdiction, admissibility, and the interests of justice. The consideration of jurisdiction has to be temporal, meaning is within the appropriate time period for court jurisdiction. The jurisdiction has to determine whether there's territorial jurisdiction, whether the crimes committed in the territory of a state party, or personal, whether the crime is committed by a national of a state party. And jurisdiction also has to be material. Is there a crime committed within the jurisdiction of the court? Admissibility includes the issues of complementarity and gravity. Complementarity meaning is there exhaustion of local remedies? Gravity meaning is the crime serious enough to merit the consideration of the court? And finally, the interest of justice. If the prosecutor concludes that there is a reasonable basis to proceed with an investigation, the next step is submission to the pre-trial chamber, submission of a request for authorization of an investigation. Together with any supporting material collected, victims may make representation to the pre-trial chamber at this stage. The prosecutor at this preliminary stage can examine material but not conduct an investigation, cannot use the investigative powers given to the prosecutor under the statute. In our view, on the basis of the evidence in the law that these two NGOs have marshaled, and which my colleague Sarah Teach will summarize, enough evidence and enough law to justify a conclusion by the prosecutor and a pre-trial chamber of the court that there's a reasonable basis to proceed with an investigation of the situation here, the crimes committed against Eelam Tamils in the context of the Sri Lankan armed conflict. The accountability of Sri Lanka for the crimes committed during the Civil War is not a new subject for the international community. The UN Human Rights Council in Geneva has been actively engaged for years in the events which ended the Civil War, attempting to get full accounting and justice for the victims. Those efforts have mostly gone nowhere, yet the efforts have not reached a dead end. The Council in March of this year adopted yet again a resolution to promote accountability in Sri Lanka. The resolution asked the Office of the High Commissioner for Human Rights to present to the Council in March 2022 strategies and options for advancing accountability. One option for advancing accountability has to be prosecution of the perpetrators before the International Criminal Court. It would seem there's an obvious match between the claim for accountability coming from the UN Human Rights Council and the availability of accountability through the International Criminal Court. The question becomes how we get these two pieces of the international human rights system to fit together. Engaging the International Criminal Court may seem to be a remote exercise in which only institutions can engage. Yet there is space for initiative by the NGO community, specifically mentioned in the statute of the court. At the end of the day, crimes against humanity will be remedied only if humanity takes up the cause of justice. Genocide will be remedied only if the people who are victimized protest their victimization. Something we see with this initiative from the Tamil Rights Group and the International Tamil Refugee Assistance Network. Thank you.
Thank you, David, for your remarks this morning. Thank you again for joining us from Winnipeg, Manitoba. Just wanted to make a note, participants on the line here today, we know that the media has joined. If any members of the press do have any questions, we will open up for a Q&A session at the end of this conference. If you are on the Zoom call and are part of the media, we will make you a panelist in which you will then be able to ask your questions. If you are not part of media and still would like to submit a question, please raise your hand and you can verbally submit a question. Thank you. I would now like to call upon Sarah Teach to provide her address for this morning. Thank you.
Hello, everyone. My name is Sarah Teach, and I'm an international human rights lawyer based in Toronto, Canada. For the last number of months, we have been working with the International Tamil Refugee Assistance Network and Tamil Rights Group to prepare communication to the Office of the Prosecutor at the International Criminal Court. In our communication, we are formally requesting that the prosecutor open a preliminary examination into atrocity crimes committed against the Tamil community in Sri Lanka. As the UN High Commissioner for Human Rights put it earlier this year, the international community has arrived at a turning point with respect to Sri Lanka. There is mounting evidence that the Tamil population in Sri Lanka was subject to atrocities that amount to crimes against humanity and war crimes, particularly in the final stages of the decades-long armed conflict that ended in May 2009. Evidence of atrocities has been extensively documented by the OISL, the Office of the High Commissioner for Human Rights Investigation on Sri Lanka. OISL found compelling evidence that Tamils in Sri Lanka were killed en masse, and that Sri Lankan government officials encouraged hundreds of thousands of civilians to seek safety in so-called no-fire zones, only to bomb them there for days on end. They found that classic civilian targets, such as health facilities and food distribution queues, were targeted, and perhaps deliberately. The shelling of the no-fire zones by the Sri Lankan government forces also attracted the immediate consternation of the UN High Commissioner for Human Rights at the time, who issued a statement expressing concern that these attacks were indicative war crimes, and crimes against humanity. Although the armed conflict formally came to an end in May 2009, the atrocities against the Tamils did not stop. More than 250,000 civilians were transferred to military-run, closed, internally displaced person camps, where they were held without charge or trial, and sometimes for years on end. OISL also found that torture and sexual violence was widespread, particularly against Tamil detainees. Then, if and when detainees were released, many of them could not go home because homes were confiscated or destroyed. Militarization of the North and East continued and continues to this day. The refugee crisis also continues to this day. Based on the 2020 figures from the UN Refugee Agency, there are still over 143,000 refugees across 64 countries, including almost 100,000 in India. Approximately 60,000 of the Tamil refugees in India are living in camps, and there are still 25,000 internally displaced within Sri Lanka. Meanwhile, the perpetrators have not yet been brought to justice. On the contrary, the government of Sri Lanka has actively obstructed efforts to promote accountability, as recently laid out by the High Commissioner's report. Sri Lankan government officials have hindered trials. They have appointed alleged war criminals and criminals against humanity to key administrative and diplomatic positions within the Sri Lankan government. And perhaps most concerningly, the emerging trends over the past year represent clear early warning signs of a deteriorating situation in Sri Lanka, including the accelerating militarization of civilian government functions, the erosion of the independence of the judiciary, the surveillance and intimidation of civil society, and the shrinking of democratic space. If Sri Lanka's domestic systems are not going to provide justice and accountability for its victims, the international community has to step up. Collectively, we need to ensure that perpetrators of atrocity crimes are brought to justice and held accountable, so that a true peace can begin and people can heal. That is what we are doing today, by asking the Office of the Prosecutor of the International Criminal Court to open a preliminary examination. At this early stage, the focus is on persuading the court that it has jurisdiction over crimes committed against the Tamils, because the International Criminal Court has a limited jurisdiction. The court can only look at crimes that occurred after July 2002, when the Rome Statute entered into force. The court can only look at crimes that constitute genocide, crimes against humanity, war crimes, or in some instances, the crime of aggression. And most importantly for our purposes, the court can only look at crimes that occurred on the territory of a state party, or crimes that were committed by state party nationals. The reason this final requirement is most important for our purposes is because Sri Lanka is not a state party to the Rome Statute. It is not a member of the International Criminal Court. This may be one reason why, for many years, this has not been tried. Because if Sri Lanka is not a state party to the Rome Statute, and crimes were all committed by Sri Lankan nationals on Sri Lankan soil, the court would not have jurisdiction. However, what has changed and what is new in the past few years is that the International Criminal Court issued a ruling in the case of Bangladesh and Myanmar that is now a formidable precedent for our case. The case of Bangladesh and Myanmar looked at the mass crimes committed against the Rohingya people in Myanmar that caused them to flee across the border to seek refuge in Bangladesh. Myanmar is not the state party to the Rome Statute, but Bangladesh is. And the court decided that it could exercise jurisdiction over the crimes against humanity, deportation, and persecution, because part of the actus reus of these crimes occurred on the territory of the state party in Bangladesh. The crime against humanity of deportation can occur as a result of a coercive environment. This is when persons are subject to such a dangerous environment that they are essentially forced to flee for their safety. This is what happened when Rohingya crossed the border and fled to Bangladesh. And this is what we are submitting happened when Tamils fled Sri Lanka in droves. Deportation by coercive environment is a type of deportation under the Rome Statute. And the court said that the crime of deportation specifically is a crime that by definition occurs on the territories of more than one state. So in the Myanmar-Bangladesh case, the crime originated in Myanmar, but completed in Bangladesh. And it was on this basis that the court held that it could exercise jurisdiction over these crimes. They ruled that it is enough that at least part of a crime occurs on the territory of a state party. And the court applied this rationale to the crime against humanity of persecution as well. In our communication, we present evidence and legal argumentation that the case of Tamils fleeing Sri Lanka is analogous. It is our position that, as in Myanmar, huge numbers of Tamils fled Sri Lanka due to a coercive environment, rife with mass killings, arbitrary detentions, rapes, torture, and more. We present evidence that this coercive environment led to Tamils feeling like they had no other option but to flee and seek refuge elsewhere. Tamils fled to lots of different countries, including multiple countries that are states parties to the Rome Statute, such as Canada, Australia, Germany, France, the United Kingdom, and Switzerland. Our argument is that, like the Myanmar case, the crimes occurred in part on the territories of states parties. So with the major jurisdictional hurdle addressed in our communication, we address it using the precedent of Myanmar, Bangladesh. We are now asking the prosecutor to open a preliminary examination. With justice not being done in Sri Lanka, and in fact, with evidence that the human rights situation is deteriorating, it is time for international institutions like the International Criminal Court to do what they were set to do, work to end impunity. Thank you.
Thank you, Sarah and David, for your remarks this morning. We appreciate you taking the time to participate in our press conference. At this time, I will open it up for questions from the press. And if anyone has any questions via Zoom, you can raise your hand and type in your questions. So I'll just take a moment to monitor the Zoom feed to see if we have any questions that have come through. Okay, none at this time. This legal opinion that we have submitted to the International Criminal Courts is a global effort by members of TRG based in Australia, UK, Canada, India, and it is a collective effort on the part of our organization. And so at this time, we're also making a call to action to the younger generation of Eelam Tamil, the Eelam Tamil community of activists, of lawyers. This is your time. This is our time to join, to come and join us and to forge ahead in the next chapter of the Tamil struggle for justice and accountability. The Tamil people have waited for over 70 years for justice and accountability in Sri Lanka. Since 2009, the assurances of the Sri Lankan government promising redress is not forthcoming through any meaningful action. In the absence of a genuine willingness to deliver justice and the democratic community for justice has no other choice but to expect international intervention without further delay to counter the systemic culture of impunity and redress for the victims of atrocity crimes and genocide. At this time, there are some questions that have come in. For those who are being changed to a panelist, before you ask your questions, I would kindly ask that you identify yourself, first and last name, your media organization, and who you would like your question addressed.
You can hear me well?
Yes, yes.
Yeah, there were a number of times that they mentioned that Sri Lanka is not party to the ICC Rome Statute. Will this have an impact in preliminary examination in crimes committed by Sri Lanka? And also, can you also outline what types of international crimes you have included in the application, please? Thank you.
Thank you for your question. Thank you for your question. I will turn it over to either Sarah or David. And at this point, I just wanted to mention that the entirety of the ICC submission, the Article 15 communication, will be available for those who are here today, who have copies available of the entire submission. those of you who have joined us virtually, the entire communication will be available in the days to come on our website. So please do follow or tag us at www.tamilrightsgroup.org. Follow us on social media and you will see an update with the official opinion. But I would like to turn it over to either Sarah or David. Sarah, if you could address that question. Thank you.
Hi there, thanks for your question. So yes, Sri Lanka is not a state party to the Rome Statute, and that presents the major jurisdictional hurdle as we've addressed in our communication. We rely on the precedent established by Myanmar and Bangladesh, and that is also why we focus exclusively on the crimes against humanity of deportation and persecution. The court in the Myanmar-Bangladesh case held that those crimes are inherently transboundary, that they necessarily occur on the territories of more than one state. And in that case, Rohingya were forced to flee due to a coercive environment from Myanmar, which is not a state party, to Bangladesh, which is. So the crux of our argument relying on that is that Tamils in Sri Lanka were similarly forced to flee from Sri Lanka, again, non-state party, to many other states that were state parties, such as Canada, Australia, Switzerland, and the United Kingdom. I hope that answers your question. I'm happy to elaborate more.
I think there was an additional portion to that question regarding which crimes are we outlining in the actual communication.
That's right. Yeah, I sort of answered both questions together. It's because of this precedent that we're focusing only on deportation and persecution, because those are the two crimes that are transboundary and that necessarily occur on the territories of more than two states. So it's actually the same answer to both of your questions. We're relying on the Myanmar-Bangladesh precedent to get over this jurisdictional hurdle of Sri Lanka not being a state party. But in doing so, we can only look at the crimes of deportation and persecution, which are two of the several crimes against humanity outlined in the Rome Statute.
Thank you, Sarah.
If I could add something.
Sure, David.
Go ahead. Yeah, the crime of deportation is to a certain extent limiting because there's many crimes within the statute of court. But it's also quite significant in the context of the Tamil population because there is such a huge refugee population. And the Tamil population is, the refugee population is almost everywhere, and they're found in many states parties. It does substantively relate to the experience of the Tamil community, and it has merit realistically in dealing with this situation. And it's not just because it fits within a jurisdictional argument that we're addressing it. There's one other thing I wanted to mention, which maybe I should have mentioned earlier, that in the legal opinion we did, aside from myself and Sarah, there was Hannah Taylor, wasn't part of the press conference, but was very much part of the legal opinion. Thanks.
Thank you, David, for your additional comments. Just waiting to see if there are any other questions coming through from either members of the press gathered here today or on Zoom itself. So I will give a few moments to collect your thoughts and formulate any questions.
It says UNCR also, UNCHR is also gathering evidence of torture, displacement, and so on. How will the ICC differ to UNCHR process? Maybe I could give an answer to that, and Sarah might want to add something as well. The UNCHR is the United Nations Council for Human Rights. The council passes resolutions. The council through the commission is gathering some evidence, but it's not a court. It doesn't make a legal determination. what it could do is perhaps ask the Security Council to refer the situation to the court. If the Security Council referred the situation to the court, it wouldn't be limited to deportation. If the Human Rights Council asked the Security Council to refer the situation to the court, and the Security Council did so, the court could examine all crimes within the statute. It can consider genocide, it can consider war crimes, it can consider all crimes against humanity and not just deportation. So in the short term, the difference is that the UN Human Rights Council is a political body and the court is a legal body. But in the long term, if the subsequent steps are taken and the council goes to Security Council, and the Security Council does a report to the court, then the court can engage the full range of crimes. So it could potentially lead to a broader outcome. Sarah, did you want to add something?
Thank you, David, for your remarks and for addressing that question. Sarah said that she feels you've covered that answer. Just checking to make sure if we have any more questions coming through. Anyone here today would like to ask a question, you're more than welcome to. We do have a freestanding mic if you have any questions for Sarah, David, or myself. We'll just give a few more moments for any other questions in the future.
Yeah, here's another one. It says, why we could not take the crime of genocide to the court. And so, again, well, it's possible if it goes to the Security Council, but otherwise, I mean, the route that we've taken as an NGO, or the two NGOs have taken, doesn't allow for that possibility. Only the Security Council could do that. Now, one of the things we've looked at is the overlap between the states voting and sponsoring the Human Rights Council resolutions and the states that are parties to or members of the Security Council. And there are 6 of them. There's 40 states that have either sponsored or voted for the Human Rights Council resolution. And of those 46 of them are members of the Security Council. And they would be obvious candidates to ask the Security Council to refer the situation to the court. Now, if you're dealing with genocide, the International Criminal Court is not the only international remedy. There's also the International Court of Justice. The International Court of Justice wouldn't bring individuals to justice, but it would make a finding against Sri Lanka as a state. Sri Lanka is not a party to the court statute, but it is a party to the Genocide Convention. So that it could be brought before the International Court of Justice is in violation of the Genocide Convention by any other state party. And that would include all the 40 states parties who voted in favor of the Sri Lankan resolution at the Human Rights Council, because as far as I can recollect, they're all members or states parties to the Genocide Convention. So there are those 2 possible ways of getting genocide before an international instance.
Thank you, David.
And again, I'll ask Sarah if she has anything to add.
Okay, 1 minute. Sarah, 1 minute. Sarah would like to make a comment.
Right, just something that I wanted to clarify that I didn't include in my earlier remarks is that there are generally 3 ways to get a case before the ICC. One is by referral by a state party. A state party to the Rome Statute asks the prosecutor to open a preliminary examination. The second way is on his or her own initiative, proprio motu. That's when the prosecutor decides him or herself to open a preliminary examination. And the third way is if the UN Security Council makes a referral to the court to look at a situation. Now, my remarks about territorial jurisdiction limitations, that the court can only look at crimes committed on the territory of a state party or crimes committed by state party nationals. That limitation does not exist if a situation is referred by the UN Security Council. I just wanted to take a step back and explain that really clearly for all the non-lawyers in the room. And basically the implication of that is if in the future the Security Council makes a referral to the ICC, then the ICC is not bound by this Myanmar Bangladesh precedent we use. It can look at crimes beyond deportation and persecution, such as genocide. And the other comment I wanted to make is that referral to the ICC, again, as alluded to by David, is not the silver bullet. There are other avenues that we should and plan to consider, such as the ICJ, the International Court of Justice. So this is an important avenue of justice, but certainly not the only one. And yeah, I think that's basically all.
Hi, we have two questions in the chat as well, so I'll read them out, probably directed towards David or Sarah. How does this legal submission from Canada, how will it add strength to the recent submission filed by Global Rights Compliance, or GRC, in the United Kingdom on similar charges around the deportation and persecution? This question comes from Arlo Rajivan, also gives his best wishes.
Thank you for reading that question. We here at Tamil Rights Group have looked at the submission by Global Rights Compliance, and we are hopeful that, and we feel they've also put forward a very strong case, similar to the kind of deportation, complementary to what we have done here today. And we wish them well in this endeavor. But at this time, I did want to turn it over to Sarah, who has had a chance to have a preliminary review of the GRC opinion, and just to draw on some key significant differences or similarities between both of the opinions. Sarah, would you mind?
Thanks, Pat. One thing I want to make clear right at the outset is that this communication is not from Canada. It's not from the government of Canada. It's from two scrappy NGOs at TRG and IGN. So just to make that really crystal clear. In terms of the GRC submission, the content of their legal argumentation is different from ours. They focus on Tamils in the UK in particular, and they have the legal theory is of continuing deportation. So deportation is a continuing crime. Beyond that, I'm a little hesitant to speak to the details of the basis of their argumentation. I'd encourage anyone to reach out to them. Basically, our position is that the two arguments are different, complementary, and the more submissions, the better. I mean, anything that gets this case before the International Criminal Court is a win in our case. Thank you.
Also have another question. Has the Myanmar and Bangladesh precedent been used in other cases, or will this be the first one? And then the second follow-up is, do these submissions adopt the same or exact tests set out in the Myanmar Bangladesh case, or is there an expansion in some way?
I will turn it over to either David or Sarah to answer that question. David, did you want to?
I mean, there have been other submissions to the prosecutor based on the Myanmar precedent. The prosecutor in the last 2 years has produced a report, a public report, about requests for preliminary examination and her response to them. And so you can see in these requests for preliminary examination, some of them are based on the Myanmar precedent. And I can remember in particular that there was a request in relation to China and Uyghurs that went from Tajikistan and Cambodia, which are states parties, and were sent back to China. And so there was a request for preliminary examination based on a Myanmar precedent about that. The prosecutor in that request basically told the people who were the NGO who put in the request that she needed more information. She didn't dismiss it out of hand. It remains to be seen where that would go. In terms of differences between the Myanmar precedent in this situation, well, it remains to be seen whether it's legally significant, but what happened with Myanmar is the deportation was to Bangladesh, which is a state party and is territorially contiguous. Here we have, Sri Lanka is an island, so there's no state that's territorially contiguous. There has to be some traversal of waters. But there are, and the closest, of course, is India, but India is not a state party, but there are some Tamils who've gone by sea to Australia, which is a state party. And so there may or may not be an issue about does it make a difference whether they're traversing international waters? And our view, it does make a difference. But that's a legal question which we addressed in our submissions. So those are my answers to those two questions.
Thank you. Thank you, David. Sarah would like to add a comment.
Thank you. So, as David said, Sri Lanka is an island state. Tamils cross the sea to get to Australia directly. But in addition to that, certain groups of Tamils fled to perhaps, for example, India first, or Malaysia, or Thailand, which are not states parties, and then from there on to Canada, Switzerland, UK, etc. So that's a form of what we call the indirect deportation. And so the one expansion that we propose is that deportation continues until they reach their final destination. But even if we don't, win that proposed expansion, there is still deportation directly from Sri Lanka to Australia, just crossing the sea. And our view is that that's perfectly consistent with the Myanmar decision, because the court ruled that deportation necessarily occurs in the territories of more than one state. And of course, the high seas is not a state. That's one thing I wanted to add. And if any of you are interested in further detail on that, I would encourage you to read the submission where we address these points in quite a bit of detail. Thanks.
Thank you. I think those are the questions for today. If there's no other questions from the audience, we have questions from the audience. Please go ahead.
Yeah, let's say.
Sir, I'll give you the mic.
You can. I'll give you a mic. You can definitely take your mask off if you're comfortable. And identify your name.
I'm Roy. My question is, say, let's take the positive side of this. You guys won the case. There was indictment, and the perpetrators were not sent for punishment. Sri Lanka refused, like what Markham did. Right? So then what happens? Of course, we won the case, but what would be the next step from the legal side?
I will ask David if you wanted to comment, and Sarah as well if you have any comments regarding.
Well, all parties to the court statute have a duty to cooperate with the court. And so if there's somebody against whom a charge or an accusation or an indictment issues from the court, the state's parties have to cooperate in bringing that person to the court. So if somebody's indicted from Sri Lanka and that person shows up in Canada and Canada is the state party, Canada has to send that person to the court. So the effect of the indictment, assuming Sri Lanka is not cooperative, is that the person cannot go can't even enter the territory of any state part of the court, which can be quite a problem. And because, as Sarah mentioned, many of the perpetrators remain in power, but it inhibits the effective functioning of government when a person cannot leave their country. And we've seen that in other countries. Again, I can give an example from China, where Bo Xilai, who was the Minister of Commerce in China, he wasn't actually prosecuted, indicted by the court, but he was just subject to a lot of lawsuits in different countries because of his persecution of Falun Gong, and eventually he was kicked out of the cabinet because of that. And he's now in jail in China for other reasons. But it's not something that a person, once you're indicted by the International Criminal Court, it's not something you can just ignore. You can't say it doesn't really matter. Yeah, so that would be my answer.
Thank you, David. Sarah, did you want to add anything to those remarks? Okay, thank you so much. I think we have one more question that's come through on Zoom. If someone could just read out that question for me, thank you.
Yeah, justification for accountability may be substantiated by a referendum for a political solution in Sri Lanka among refugees, diaspora, and homeland Tamils. Is an internationally supervised referendum a possibility, and what are the modalities for one?
This is definitely a very interesting question, but also one that lies in the hearts of many of our community members. I think it's beyond the scope of the conference here today, but this is something that we at Tamil Rights Group are looking into options in which we can go about this, but that's something for another day. But thank you for that question. Sorry, David.
I was just saying there may be a legal component to that, to the answer to the question. Because if you remember when I talked about the considerations that the prosecutor has to address in determining whether or not a preliminary examination provides a reasonable basis, one of them is the interest of justice. If you look at the prosecutor's report, the prosecutor says the interests of justice are a countervailing consideration. Do the interests of justice work against the prosecution? And I mean, it's kind of cryptic what she's saying there, because this was the previous prosecutor, but my understanding is what that means is in some cases where these mass atrocities, what you get is internal reconciliation efforts. Where there are these internal reconciliation efforts, it may work against the interests of justice to prosecute at least some of the perpetrators. And so this question about the referendum relates to that issue, whether there can be internally within Sri Lanka some sort of reconciliation of which a referendum may well be part. And if that sort of reconciliation were to occur, truth and reconciliation, then it may work against, it may be not in the interest of justice to proceed to court. So that's how it comes into play legally, at least the way I would see it.
Thank you, David. At this time, we are now closing the question and answer period. I would like to take the opportunity to thank everyone who's joined us here in Toronto amid COVID protocols, so we appreciate you taking the time to come here. Also to the many members of the media, non-governmental organizations who have joined us here via Zoom. Thank you so much for joining us here today to hear us announce this next step in the long road to justice and accountability for the Eelam Tamil people. Yes, this is an initial effort by Tamil Rights Group and ITRAN, but we have a long way to go. We need the help and support of many of the organizations who are on the call today and others who will be listening to this Zoom call. We ask you to join us to strengthen our efforts to move forward. And I wanted to thank Sarah and David for joining us here today. Thank you to the Marriott facilities for helping us host, and also the AV crew that's here today to help us put this together. The Tamil people have waited for over 70 years for justice and accountability in Sri Lanka. Since 2009, assurances of the Sri Lankan government promising redress are not forthcoming through any meaningful action. In the absence of genuine willingness to deliver justice, the democratic community for justice has no other choice but to expect international intervention without further delay to counter the systemic culture of impunity and redress for the victims of atrocity, crimes, and genocide. At this time, as I mentioned, we are also making a call to action. To the younger generation of Eelam Tamil community, the activists, the lawyers, this is your time. This is our time. Join us. Let us forge ahead in the next chapter of the Tamil struggle for justice and accountability. In the words of Martin Luther King Jr., the arc of the moral universe is long, but it bends towards justice. After more than 7 decades of the ongoing genocide of the Tamil people, the time for justice is now. Thank you.